Good afternoon, everyone, and a warm welcome to our lecture in the program on Sustainable Global Economic Law, SGEL. Today we have Professor Nehal Bhuta, who joins us and will present his paper on recovering social rights. Nehal Bhuta is Chair of Public International Law at the University of Edinburgh and co-directs the Center for International Law and Global Justice. He was previously at the EUI in Fiesole, Florence, where he also co-directed the Institute's Academy of European Law. It's wonderfully accomplished, many important academic contributions to his name. He edits the OUP series on the history of theory of international law, very steeped in historical methodology. Before the EUI, he was at the New School of for Social Research at the University of Toronto. Wonderfully accomplished thinker, contributor to international law. So we're very honored and just happy that you can join us, Nehal. My name is Ingo Fenske. I co-direct the Sustainable Global Economic Law program. And so without further ado then, Nehal, that I would invite you to present your paper to us. Thanks so much for joining us, and the floor screen is yours.
Thank you very much, Ingo, for that kind introduction, and thank you to the Amsterdam Center for International Law and its lecture series on sustainable economic globalization for this invitation. I was sorry I couldn't be there in person. Circumstances unfortunately didn't make it possible. But thanks to all of you for your attendance today to listen to the paper and to engage with it. So you've got a fairly lengthy text in front of you. So there's no possibility that I will be able to take you through the intricacies of that. I'm going to try to talk for about 25 minutes. And really what I'd like to give you is an overview of the paper, and perhaps I think some sense of what I think are the key interesting arguments that I develop. And then if you're interested, we can then develop the detail of some of those arguments in the question period. So the paper itself responds to a fundamental challenge which has been made against social rights, that they are an inadequate legal and political language to address widening income and wealth inequality. In the opening parts of the paper, I set out the terms of that challenge and situate it within wider critiques of the law and practice of human rights. And that's probably the paper that I will skip over almost entirely. Many of you will be familiar with a variety of positions that I re-articulate there, and I don't want to necessarily rehearse them. That's really much more of a preliminary to the nature of the argument that I'm making. So these critiques, which have intensified and accelerated over the last 15 years, collocate several different streams of remonstration against human rights. That they are beholden to a neoliberal political economy, that they are excessively legalist and thus inadequate for deeper transformative social change, and that in any event, social rights in particular were never more than emanations of changing socioeconomic dynamics driven by other social forces, and therefore inapt to drive such changes in their own right. Growing economic inequality within states, even as the juridification and constitutionalization of social rights has flourished since 1990, appears to provide a kind of summative example of these criticisms. In the paper, I argue that these claims actually reflect a great deal of truth about the present of social rights, but do not accurately characterize their past. In the latter sections of the paper, I recover a different register of social rights thinking that I suggest has faded from our collective memories. A register which infused the discussions of social rights in the drafting of the Universal Declaration of Human Rights. I call these natural social rights or collective natural rights, and trace their lineages through English radical thought, French physiocratic thought, Jacobin and neo-Jacobin thinking, to early 20th century state theories and constitutional social rights. The essential insight gained from recovering these repertoires of social rights is the surprising extent to which social rights laid the conceptual foundations for the social state. Rather than understanding social rights as nothing more than the weak offspring of a social welfare state brought into being by social conflict, we can see them as historically powerful political ethical discourses that helped articulate and motivate the concept of the state as a public power that must organize the economy in order to ensure a society of equals. At the heart of the 19th century ideas of social right was the demand for the creation of equal social citizens and the construction of social democracy through the creation of a social democratic state. Recovering these ideas helps us better understand the ways that social rights could be a germane response to the challenge of inequality in the present. So, as I said, I'm going to really pass over the first two sections of the paper, which outline the contemporary data on inequality, which I'm sure is well known to many people here, and also the range of criticisms made in relation to human rights generally, but in particular to the limitations, in relation to the limitations of economic and social rights. And I want to focus in on what I think is probably the most influential, but I think also in some ways the most powerful of these critiques, which is the one raised by Samuel Moyn in his 2018 book, Not Enough. So in the paper, I argue, first of all, for a particular way of understanding Moyn's criticism. Not Enough is a wide-ranging book, which addresses a variety, it's sort of a kaleidoscope in many ways of different issues in relation to social and economic rights. And he gives the 19th century very little space. It's dealt with in one chapter, the first chapter, before he moves rather quickly onto what is really a history of the post-war welfare state and the dimensions of its retreat, aspects of the critique of decolonization that's raised by cosmopolitan thought and so on. So the 19th century does not occupy much space in that argument. And one of what seems to me the most important elements of his argument is both historical and conceptual. And so I would maintain that Sam's fundamental claim in his book is not that economic and social rights are always and at all times merely demands for sufficiency. Rather, it is that social and economic rights are Janus-faced and chameleon-like concepts, the concrete content of which depends on the wider political and economic ecology of the given moment in history that surrounds them. Thus, within a mid-20th century global embrace of the state as an interventionist agent of economic management, provider of public goods and supplier of services from telecommunications to healthcare, economic and social rights represented a kind of shorthand summary of the expected outcomes of an ambitious project of egalitarian national citizenship. This project, the welfarist project, rested on a theory of national states as robust and effective collective agents that not only mitigated the effects of national and global market capitalism, but remade and contained it in order to achieve, create and maintain a stable political and economic order, one which aimed to manage, if not permanently resolve, the critical contradictions inherited from capitalism's anxious triumph in the 19th century. On this account, the codification of economic and social rights that takes place in the Universal Declaration on Human Rights and in the International Covenant on Economic and Social Rights were emanations of a political economic context, and this context provided the essential presuppositions for what we might expect the rights concepts to denote and index. While the rights read alone could be understood as mere guarantees of sufficiency, they were, in this political economic context, refractions of a moderately egalitarian enterprise in which achievement of these guarantees rested on the theory of a strong state with redistributive and levelling up ambitions and programs. To use a contemporary term anachronistically, the historical state concept presupposed by economic and social rights in the context of their codification was a market-shaping state concerned with creating public values such as deproletarianization and expansive public education programs. The denouement of this story is that the juridification of economic and social rights is symptomatic of a political, economic, and social matrix of forces which lies somewhere else. The independent agency of the rights concepts and rights language as a framework of thought and action is limited and marginal. Critically, in this argument, the concepts of rights are unable to bring into being the presuppositions of their egalitarian possibilities. As those presuppositions are eviscerated from the 1970s onward, as our state theories and state concepts are reworked under a different constellation of economic forces, political agents, and social movements from left to right, social and economic rights lose their connection with the political economy upon which they leaned. Stripped of this concrete historical relationship, we are left with juridical concepts to which elaborate juristic content can be given, but where the political ethical foundation of those concepts in a deeper political and economic movement recedes from public and private recollection. Instead, the juridical concepts are mobilized by those best equipped to articulate them and directed towards those institutions most adept at hearing them: lawyers and jurists, international expert committees, and courts. Once such concepts become principally juristic in their mode of determination and activation, they can, like any positive juridical concept, be positioned as boundary concepts for the legality of this or that program or policy, but appear largely untethered from a programmatic structural commitment which is inscribed in the purpose of the state as a material and juridical order. Hence, Moyne ultimately dismisses the contemporary possibilities of economic and social rights as playing, quote, a defensive minor role in pushing back against the new political economy of neoliberalism. So to put it a bit aphoristically, one way of summarizing this claim about social rights that is, I think, best made by Samuel Moyne is that the welfare state made social rights. But once the welfare state is dismantled and disaggregated, social rights cannot remake the welfare state. Now, if this is true, it seems, then probably the most damning argument against social rights is that they can at best reflect an existing political economy rather than have a role in shaping a new one. And that does seem to me to be a powerful critique of social rights in the present. And to the extent that social rights in the present have become essentially juristic concepts, right, articulated by lawyers, addressed to expert committees, even in the preoccupations with constitutionalization and legal enforcement by courts, it seems to me that even if all of those things are successful, this critique would still stand. That fundamentally a juristic account of social rights is unable to articulate a political argument or a political foundation that is strongly oppositional to the political economy of the age. Now, perhaps I think the most devastating aspect of this claim is the notion that there is no real history of social rights before 1900. Right? That the welfare state, or our interest in the welfare state, or our concept of the welfare state came first in a variety of contexts. And as that crystallized and was materialized, mostly from 1940 onwards, we attached to that our ideas of social right, right? Basically a summary of what we expected the social welfare state to do for us. I think what you might say is that at the heart of my argument is that there is a different historical story here, that there is a language, a political and moral language of social rights that is recognizable, and in some sense recognizable to us, from the end of the 19th century, or even, sorry, from the end of the 18th century and the beginning of the 19th century, that at various moments in the 19th century actually helped crystallize and shape our idea of the social state. So to that extent, you might say, one of my core historical claims is that, to a surprising degree, the language of social rights helped articulate the vision of a state, right? That it subtended the idea of a state, the purpose of which was to organize the economy, rather than simply protect what we might think of as classically liberal rights. Right? So I think that's the fundamental point of the paper from a historical perspective. But along the way, I sort of move backwards, or rather in reverse chronological order. I start with an examination of the ways in which the delegates who were involved in drafting the social rights provisions of the Universal Declaration understood the concepts that they were talking about, and try to put my finger to some degree on some of the main sources of influence for that understanding. So one of the conclusions I reach in that portion of the paper is, first and foremost, that if you look at what delegates said and some of the influential underlying documents that contributed to the drafting of the social rights provisions of the UDHR, you actually have a much more expansive notion of the relationship between state and economy than is evident in the text itself. Underlying the concepts of rights is really an idea of the state as a public power that would be the provider of public goods, that would organize the economy in ways that we would associate with a great deal of planned intervention in order to guarantee these rights. So looking backwards from the perspective of 1945, what's striking is the extent to which there was a great deal of agreement that social and economic rights rested upon and required a social democratic state, even among delegates from the United States. Now, digging a little bit further into that, one of the things I observe is that a very influential document in the drafting of these provisions of the DHR was a survey of world constitutions that takes place at the behest of the Secretariat, in which Latin American constitutions play a prominent role. Now, by 1945, a number of Latin American constitutions had created in their constitutional rights provisions what we would think of as social rights: the right to work, the right to social security, a right to health. These constitutional provisions, it seems, were directly influenced by the Mexican Revolutionary Constitution of 1917. Now, my point about all of this is, looking backwards to the Mexican Revolution, there's no sense in which we might say the language of rights here was derivative of any kind of actually existing welfare state. So it seems not quite right, historically speaking, just to argue that the welfare state came first, or our concept of the welfare state came first, and that that social rights were simply a summary of that. Instead, I think what we can see in 1917, but also in the Indian Constitution of 1947, is the use of a language of right in order to forecast or to foreshadow a material constitution, an economic order that was to be put in place and which would be anchored in part in the Constitution. The Constitution was a document which was not necessarily guaranteeing rights to individuals to claim through courts against the state, but rather it was trying to structure the boundary between the economic and the political in a way that directed the economic to achieve certain ends. So I call this an objective conception of right, an ordo not a jus. And so the critical point that I wish to make in relation to in the first part of the paper is really that the language of economic and social right, or of social right, certainly precedes the 1940s, and that where we go and look for it in the Indian Constitution, in the Mexican Constitution, the Latin American constitutions that were influential in that drafting, what we find is a concept of right that is about authorizing the state to take certain kind of activities, to undertake certain kinds of things in order to achieve economic outcomes. It's not directed at a kind of subjective idea, but rather a set of guarantees in the nature of the economic order that are to be brought about by the collective agent, the states, as a public power. So that's my first observation. And in a way, what this points us to is the sense in which our state concept, right, our concept of state as a public power, a critical function of which is to organize the economy, precedes the articulation of social rights as human rights, but does not in and of itself bear no relationship to the rights themselves. The language of right here is used to articulate this concept of the state, to subtend its authority and legitimacy to do these things. And thus the Mexican Constitution contains a catalog of rights, some of which are explained at great length in the Constitution itself, as authorizing the state to do certain things. So where did that come from? Right? And here, I think what's interesting about this story is that one can identify lineages of this kind of social rights, of these kinds of social rights concepts, stretching back, I think, even to the physiocrats. Right? So the second half of the paper, which is much lengthier, and which again, I think I won't unpack in great detail just because I think it would be quite time consuming to do so, essentially traverses a history, pardon me, from 1700 to 1900. And the key sort of stage, the key way stations of this history are first an articulation of something that I call natural social rights or collective natural rights that's discernible in the discourses of English radicals, including the precursors of English radicalism, which was the level of thought of the English Revolution, and in even in the physiocratic thought of the early 18th century in France. Now, physiocratic thought, of course, is mostly associated with a commitment to what we would think of today as liberal rights, although they didn't understand them in those terms, rights which guaranteed the natural order of the market. What's striking, and I think this is the work that's been done by Dan Edelstein, is one of the consequences of the apparatus of physiocratic thought was to insist that natural rights were not alienated to a sovereign once society is formed. Right? The alienation thesis was a kind of mainstay of an important lineage of natural rights thinking from Grotius to Hobbes and beyond. The physiocrats repudiated this and rather insisted that the purpose of society was to realize natural rights in society. So somehow the social becomes the guarantor of natural right. And within those natural rights, of which the social is a guarantee, or must guarantee, is some notion of the right to public assistance, or the right to a share where one is unable to participate in the market. Now, the physiocrats were obviously not very concerned with distributive equality. They believed that the functioning of the market according to natural law and by the guarantee of essential natural rights, including property and liberty, would provide. But in the event that someone was unable to participate in the market, there was an expectation that they too would be guaranteed a certain minimum, a social right, in the form of assistance. So the first important conceptual change, I think, happens here, where the social is understood as the guarantor of the realization of social rights in society, under a market society. But a market society was understood at the time as one which would bring about a society of equals, because a market society was one that repudiated both mercantilism, but also aristocratic privilege, ultimately, in the physiocratic account. Now, I think there's an interesting transformation that takes place under the democratic egalitarianism of the revolution, in which it's common ground among all who speak of natural rights that the social should guarantee natural rights. But the Jacobin ascendancy brings with it a redefinition or a reappropriation of the concept of social right, which goes from being merely some kind of right to assistance, in the language of the physiocrats, to becoming the right to a fair share. And it's this register of the right to a fair share that I think is very powerful and very consequential throughout the 19th century. As I document in the paper, the legacy of Jacobin thinking for 19th century republicanism was very strong. And the language of natural rights, of what I call natural social right, reemerges in the 10 or 15 years after the revolution, in the language or in the political speech of neo-Jacobin thinkers who form political clubs, often bearing the title, the Society for the Rights of Man or something similar. These figures, writing in the 1930s, start to turn the concept of rights into a demand to organize and address the what they call the right to work. Right? So their use of the language of right begins as a response to the consequences of industrialization and industrial capitalism. And it's not a language of property, it's rather a demand that requires the organization of the economy and the limitation on property. So this becomes significant and powerful in French Republican thought in the 1830s and 1840s, but it also is visible in a stream of English radical thought associated with the Chartist movement between 1920 and 1940. And there's a remarkable, in my view, similarity of concerns. Both of these agents, or both of these kinds of actors are preoccupied with the consequences of industrialization. The promise of the physiocrats and the promise of those who advocated commercial society, such as Adam Smith, the promise that this kind of society would generate a society of equals by destroying aristocratic privilege and guaranteeing equal legal relations between all citizens, of course, has been betrayed. And the consequences of commercial and industrial society for economic inequality become transparent for anyone who is observing the economies of France and England in the early 19th century. So it's essentially as a response to this observation, as well as a response to the denial of universal suffrage, which is contemporaneous to the aftermath of the revolution, that the language of right is conjoined to the political and the economic simultaneously. So I think this is probably another interesting consequence of this argument, right? The argument is not the argument of T.H. Marshall that said, well, first came political citizenship and then came the demand for social rights, and then so first came civil, then political, then social. I think what we can observe in these 19th century discourses is the social and economic were completely conjoined. Both the Chartists and the Neo-Jacobins, writing around the same time, understood that that the monopoly on political power possessed by the propertied classes was generating great economic inequality, and they attributed that to a sort of failure of public power, or rather a capture of public power by those who had property. So for them, the universal suffrage was not a political right from which an economic right would follow. Rather, universal suffrage was a demand for a truly public power. And a truly public power, pardon me, would cease to be a corrupt power because it was truly public. And once it ceased to be corrupt, it would act to organize economic relationships to ensure the fair shares for all. So the register of fair shares was closely connected to the language of right here. And as I traced in the paper, I think there's very, very strong resonances here to a variety of deeper Republican discourses, right? That a society or a public order which denies or which allows the excessive accumulation of income and wealth and the capacity to accumulate income and wealth turns those without income and wealth into the equivalent of slaves, because they are subjected to the arbitrary will of others, the arbitrary will of property owners. So the proper corrective for that consequence on liberty is in fact to transform the nature of public power into one which constrains or defeases the excessive accumulation of income and wealth, and also mitigates, or if necessary, simply reorganizes the economic dynamics which generate that accumulation of excessive income and excessive wealth. So there is inherent in this use of rights a very strong affinity with the lineage of Republican thought, which understands the basic purpose of a political order to be non-domination, and in particular, the protection of liberty, which means not liberty to do what one wants in the Hobbesian sense, but liberty in that Neo-Roman sense of freedom from the arbitrary will of others. And in this logic, in a society where a very few hold a great deal, we are not free from the arbitrary will of others because of all the ways in which we depend upon those who have accumulated great income and great wealth for our livelihoods. So this resonates then with the argument about the right to work. The right to work is a demand not for a job per se, but rather for the organization of the economy, which not just provides employment, but which ensures that labor gets a fair share of its contribution to the wealth of the society. So the language of the right to work, which is articulated most famously by Louis Blanc in his 1840 text called The Organization of Work, is observed by a contemporary German living in Paris at the time, Lorenz von Stein, or Lorenz Stein as he then was, who argued, in fact, that the demand of people like Blanc and the other Neo-Jacobins for the right to work, which entailed, in addition, public education, which entailed for them a basic level of protection and insurance. All of this was associated with the concept of the right to work, because the right to work really meant the guarantee of a fair share for all, for those who labor. That concept in Lawrence von Stein's argument signaled the earliest idea of social democracy. Right? Von Stein, who really in many ways coins the concept of social democracy in his book in 1848 or 1850, argues that the right to work is really a demand for a particular kind of state. It's a demand for a public power that provides public goods, that limits and constrains arbitrary power, which is achieved through the accumulation of excessive wealth and income, and which provides to all citizens the social foundations for democratic citizenship. And it's Stein's argument that leads him to the conclusion that what's really required in order to realize the vision of Louis Blanc and others is something called the social state, right? In which the state is, in the words of Stein, is not only the greatest, is not only the highest administrator, but also the greatest capitalist. So just then to conclude my opening remarks, and I've probably spoken a little bit too long, the key sort of point that I'm trying to develop here in this paper is first and foremost that there is a history of the concept of social right, which is closely or intimately connected to the critique of capitalism in the early 19th century. And that this concept of social right issues in an argument about the nature of the state and what it is for. And the articulations of these ideas of rights shape the articulation of the nature of the state and how it should realize these rights in reality. My argument is that these were extremely powerful and influential throughout the 19th century, that they in many ways undergirded a concept of slowly and over in kind of fits and starts. They transformed the concept of social of the place of the state, but they also helped transform the nature of economic thought. One of the direct influences of Stein was in the creation of the Verein für Sozialpolitik, who were preoccupied with ways in which the state needed to organize the economy in order to address social concerns and social harms. But I think more interestingly as well, it created a set of expectations, a horizon of expectation of, by the end of the 19th century, about what the state was for and how it should be made to be that way in reality. And I think it seems to me that that dimension of social rights, which is really about recovering a claim and a set of ideas about the relationship between public power and private power, is still very useful for us today. Thanks very much.